Moving into a Q&A session about the district plan. It's possible we won't need 2 full hours, but, go hard with your questions. It's very important. Over to you, Sean. Did you want to introduce or just go straight into it?
Oh, I can say a few things to get us started.
Great.
Very good. So this is the final question and answer session before your consideration of the district plan on Thursday. This has been scheduled in largely so that we can deal with any final queries you have before taking those votes in that determination process. So there is no agenda for today.
Great. Well, I'll start taking questions in that case. We'll start with Councillor Matthews.
All right. So my first one really is to do with the disappearing property economics report, and that was provided to us, and then I'm assuming for legal advice reasons was withdrawn. And I guess I'm interested in, first of all, the fact that it isn't live means that we're making decisions based on recommendations without any kind of analysis of what the impact of those decisions will be. And my question really, did the IHP meet their obligations in terms of reporting to us about the cumulative effect of those recommendations?
So, first of all, I commissioned the property economics report because I believed it was important that an informed decision was made, and also because I would need the data myself for the forthcoming assessment of housing and building assessments, which is another part of the NPSUD. So that's the primary reason for the report. The reason it has been withdrawn is because ultimately we determined that the need for the sections of the RMA which required you not to consider new information were more important than the ones that I was looking at under the general decision making. So that is why that has happened. If it has caused you any trouble, I apologise. In terms of has the ISPP discharged their requirements to you? Yes, they have, but as you well know from the discharge of my own duties to you, there is a resolution that goes with that in terms of how detailed that is. But on the face of it, yes, they have discharged their duties to you.
And I have asked for legal advice about whether the IHP have met their obligations under the NPSUD more generally. Is that advice still coming to us? And if so, when?
So it's a question that has been exercising quite a number of my colleagues.
I'm sorry.
Bear in mind that this is a fairly new process. So on the face of it, yes, on the face of it, the question of whether the NPSUD has been met is a question that councillors will have to satisfy themselves of. There isn't a definitive legal opinion that says no, that it hasn't been met.
And my third one in this round is about legal advice to us, because obviously we've been being very, very well behaved in limiting our public comments in any kind of way and not listening to new information. And how does that, can you explain to me how that process changes when we go to make decisions, and subsequently in terms of what we can say to the media or the public about our decisions after we've made them?
Certainly. So, first of all, sitting in a quasi-judicial capacity for a democratically elected body is quite a constitutionally difficult thing to do. That quasi-judicial process lasts through to the determinations. So at the moment we are still in predetermination. And Thursday you'll be determining and then determined. Sorry, I feel like I'm doing Latin class. What that means is during the debate, as you're making your decisions, you have then been freed of that predetermination. So you can say what you think. What you cannot do is introduce new evidence from outside the process. After the debate, again, you are free to exercise your roles as democratically elected representatives of the people. You can say what you think. However, it is important in your comments that you continue to respect that no new material was part of your decision. So what I'm saying is it would be most unwise for you to then reference material from outside the process that you made your decision on, because you didn't do that.
Just one follow-up to be very clear. We can talk about previous iterations of the decision, say for the spatial plan and the proposed district plan, and the information that was provided to us as part of those processes, for example.
So, is this after the decision or during?
After.
So after the decision, yes, you could.
Councillor McNulty.
Forgive me, because I feel like I may have asked this, but it's been a few weeks. Did we land on a legal position around, I think we've established as a matter of fact that the panel gave weighting to verbal evidence over written submissions from their own words. I think that's a fair statement. Did we establish on whether there was any issues with doing such in this process?
Ultimately, the weighting of submitters and the conclusions of the IHP are the things you're deciding on. If you believe that evidence has not been weighted correctly, then it is within your power to change those to reject those recommendations and alter an alternative to address that problem.
Councillor Chung.
Thank you. I have two questions, mainly based on the huge number of emails that we've been receiving, sort of making various statements. So I just want to confirm the veracity of them. One of them is the IHP commissioners.
Councillor, would these be emails that you're not considering?
I'm reading them, but I'm not considering them.
Excellent. I'm most comforted to hear that.
Yeah. So there've been a lot, and I do accept that a lot of these are given to groups of people, and so the emails are all fairly similar. But one of the allegations that they pass is that
Councillor Chung, for your own protection, it's probably we can't go into details that weren't considered as part of all the submissions, and it's technically new information. So
no, it's not new information. I just want to ask a question that that these submissions have been put to us, and so I just want to check to see if that's actually been considered or done or.
The emails?
I think it might be safer, Councillor, if you just shared those with Sean later, and we can cross-check whether in fact they are part of an original submission or not. But for the purpose of this session, it's probably best that we stick to the evidence that was presented to the panel and the panel's recommendations and how you may or may not agree with them.
Okay, yeah, sure. Okay, so the second question is that, and it's not referring to that, is that when we go into debate on these things and we say that after reading all the submissions, we want to check the validity of a particular statement. Do we need to, or should we refer to that particular submission?
So, if I understand your question, say you are most concerned about the colour of my mobile phone, and you have received, the IHP received 4 submissions saying it should be yellow, purple, green, and gold. You're quite interested into the submissions that would make it gold. You're asking whether you can then refer to that submission.
I'm asking whether we should or we need to.
So if you are looking to reject a recommendation of the IHP and offer an alternative, or you don't have to offer an alternative, then yes, you would need to reference the submissions you are drawing your evidence from.
Oh yes, okay, that's my question. Thank you.
Councillor Pennant.
Thank you. Sean, can you just triple confirm that the panel was duly constituted, so there was a vote in the last triennium and there's no legal issues with the way they were appointed or exercised their function?
Yes, the appointment of the independent hearings panel was done by vote of committee. I'd have to look up the date. And the replacement of the commissioner, which has resigned, also took place under a duly appointed process. I'd have to check the date for that one as well.
Okay, thank you. The property economics report that you mentioned, just double confirming again that will be released. It's just that obviously we can't consider it now and we won't be able to consider it later, but presumably we can talk about it at some point.
So yes, that will be released. Like I say, it will be required for the HPA updates that are to be done. I haven't got an exact date of release.
Sorry, I thought your email said Thursday, was it?
I said I will have to release it after Thursday.
Oh, after Thursday. Oh, right, okay, sorry. Okay. Yep.
I'll look to do that as soon as I can. The important thing is that it is not used as a factor in your determinations on Thursday.
But after the determinations, when we've done our determining, we are still allowed to debate the issue, right? So then it becomes a political issue from then on, and then we can talk about any other information that's come to light.
Yes.
Just for clarification, yeah.
Yes, so it would be most unwise to say that you made a decision based on that report.
No, I'm not. No. It's just now
Good.
that we've got because we only were given that information inadvertently only a few days ago, right? So yeah, no. Be very careful about the process. As you know, just last question. As you know, I'm very interested in stormwater and how we look after it. So I guess I'm just wondering, is it within the bounds of what's an appropriate question, to see whether you think that the panel has got it right in terms, because they're trying to balance a whole lot of things, right? In terms of cost and whether responsibility lies for managing it in the central city?
So my opinion did not go to the panel, so it wasn't a thing the panel considered. So I would think it best I do not give you a judgment on that.
I can only ask Ms. Cook. Is that?
Yes, you can ask Ms. Cook, though. I'm not sure she'll be able to comment on whether she believes the panel have got it right, but she can tell you about the implications of the panel's decision.
Right. Okay, and is there going to be any further chances to ask questions on Thursday just because there's some amendments coming forward?
Yes.
Yeah, can help with that.
Yep. Thank you. Councillor Randall.
Thank you. First question is really about what the Minister is able to do from this. I've received conflicting information around the for what the Minister is able to do for any proposed district plan rule that are recommended by the hearing panel, but with which we decide that we object to it and we suggest something else. The two options I've heard is the Minister can only choose between the two options, and the other one is the Minister does have the option to make a different sort of rule that's separate from either of those two options. Can you give us some advice about what is the Minister's freedom of action?
So now I'll ask Karen from our legal department to join me. Karen has been looking into this for me. As you can appreciate, it's quite a new process.
Kia ora, Councillor. So what I would say is our reading of the legislation is that he can choose to accept or reject the recommendation that has been referred to him, and then if he rejects the recommendation, he can choose to accept or reject the alternative recommendation that Council puts to him.
So just to be clear, his process is whether or not he accepts or rejects the Commissioner's recommendation, yes. And then if he does reject it, he can accept the Councillor's recommendation, but can he accept something else?
No, he doesn't have the ability to create a new alternative recommendation.
Like you can't say, I want it halfway in between. You know, if for example, the Commissioner's recommended 10-minute walking catchment and the Council decides they want a 15-minute walking catchment, you can't say, let's make it 12 and a half.
No.
Okay. Thank you. That's very helpful. Secondly, there is talk, about considering evidence that's not being presented to the independent hearing panel. Can you just maybe outline what would the consequence be if the council was found on a significant point to have considered evidence that was not put towards the hearing panel?
So, the primary risk is that of judicial review. Judicial review is essentially a judge looking at the correctness of a process. Because the law is very clear that you cannot consider a matter that was not put before the panel, that would mean a judge would be likely to find in their review that there was a problem with the process, and they would then order the process to rerun generally. So
I'll just jump in there. Sorry. So there's kind of a variety of things that a judge could do, but essentially what would happen, what would be open to them if they determined that the process had not been correctly followed, would be to quash the decision and then send it back for the decision to be remade.
Okay, and so lastly, and this is probably as much for the chair or other officer advice. Thinking ahead to the meeting tomorrow, if a councillor believes that evidence has been put forward that's out of scope and may cause this risk to occur, what should happen as far as the meeting procedure? What's your advice about what meeting procedure should happen at that point? Because we don't want to have gone through a process where the wrong evidence has been considered either during question and answer or during debate.
So,
do we raise a point of order? Do we?
I think we've discussed this eventuality, Councillor, and I think the conversation between myself and the chair is that we'd adjourn and get advice, similar to what we normally do in local government proceedings. So, and if that advice is easy at hand, then we'll return and reconvene the meeting and tell you what the advice is.
I think we're going to be prepared to pause a fair bit throughout this meeting, just because of the seriousness of it.
Sure.
So that is a good question, and
Thank you.
No, that's right. Deputy Mayor.
My questions are around the hydraulic neutrality meaning. So I'll just say I did have a discussion with officers this morning, but I do just want these questions to be in public. So the commissioners have recommended changing the meaning to what we had in the proposed district plan. And so what I want to understand is, what is the meaning that is used amongst Wellington City Council, Greater Wellington Regional Council and Wellington Water? And will we all be using the same meaning? And if we are not, how will we get to the place where all three regional organisations will use the same meaning?
Certainly. I will just ask Ms. Cook to join me, please.
Kia ora, councillors. Just would you be able to repeat the question just so make sure that I can understand fully what you're asking?
Yeah, so it's commissioners have recommended that we change the meaning of hydraulic neutrality than what we put forward in the proposed district plan. So then what is the meaning that is common amongst Greater Wellington Regional Council, Wellington Water and Wellington City Council for that term? And how will all of those bodies work to align their meaning if we go forward with a different meaning?
So the current recommendation from the commissioners is out of line from the hearing stage of the regional policy statement. So there is a misalignment between our two processes. We are slightly ahead of the regional policy statement. So while there is a misalignment, I cannot say with certainty that that will stay, but in the future we will be working to get as aligned as possible.
So what that alignment would mean is if the regional council were to take a different position, or the government was to define hydraulic neutrality differently through a national policy statement, those higher order instruments would then instruct a plan change to bring the district plan into consistency with them.
Right. So in everyday terms, when a developer is applying for a resource consent and they have different meanings from each organisation, how will they be able to solve that situation? Or how will we solve it for them?
So the difficulty will come if there are different types of consent that are required. And so we will have to have a look and see what is on the table when the regional council make their decisions. And what will normally be done is we'll look to incorporate their consents into a single process. But until I know what I'm dealing with, it's quite difficult to give you a definitive answer.
Thank you.
Councillor Free.
Yes, just some thinking around some of the specific properties that are identified with heritage listing currently. What sort of rights have we got to just decide that we think that they're not worthy of being listed as heritage? And
So,
what sort of evidence are we allowed to consider or not consider?
So not all heritage buildings have scope. So what I mean by that is not all heritage buildings have been submitted on or been subject to independent hearings panel decisions. There are some that have. For those that have been subject to decisions and to recommendations and submissions, you have the opportunity, just like with anything else, to weigh the evidence of those submissions and the 42A reports and the hearings panel's deliberations, and decide whether you believe that the building should be listed as a heritage building or not, or removed from the heritage list.
Is that what we have to do? We have to decide, to make that decision to vote against for something different from what the panel have recommended. Like, for example, the Gordon Wilson building. Would we have to actually look at every single bit of evidence that was submitted and the report to be able to confidently make another decision, a different decision?
So the law does not require you to consider submissions. You can simply consider the IHP recommendations with the deliberations. If on the face of it you do not believe that was a heritage building, then you would vote not to accept those recommendations.
But you're not necessarily obligated to read every single bit of evidence submitted.
No, you're not. But if you do decide to consider submissions, you need to consider all of them.
Yes.
So it is a fair process.
Okay. So, but if you decided that you didn't need to look at all the submissions or none of the submissions, which would be either one or the other, then you should still look at the hearing.
Yes.
Write-up.
Yes.
And something else?
No, that's
just the hearing write-up.
Yes,
just the report. Okay,
that's all.
Okay, thank you.
Councillor Brown, and then we'll go on to round 2 of questions.
With respect to Chris Bishop's deliberations that occur next, assuming we recommend some changes, is he restricted to the information which he or his officials could actually use? And I mean, for instance, if I send him a letter after we decide about why I think council is wrong, as an example, is he allowed to actually consider that?
So the minister does have a slightly different ability to take into consideration matters than what you have, but it is also the same. So he still can only take into account those matters or those considerations that the IHP could have taken into consideration. So no, he wouldn't be able to consider anything that came post that, I would imagine.
Want clarification on this, though, I guess that we're only allowed really to consider the information which has actually been part of the process, and because he could only either decide to back the commissioners or our alternative position, he can't go outside that scope either, really.
So it does appear that he could consider, and I guess this is sort of something that he will presumably be receiving advice on, that he may be able to take into account things that are not specifically evidence or submissions, but they would still have to have been considerations that the IHP could have taken into account when making their recommendations. So they couldn't be things that have arisen subsequently to the IHP making their decision.
Councillor Matthews.
Just got a question about the transfer of legal risk from us to the minister and how that happens.
So, in the resolutions that are, the motions that have been put to the council on Thursday, you have the option to accept the recommendations of the commissioners or to reject them. If you accept them, then you are the decision maker and you have made a decision, and therefore you will be subject to the risk of judicial review. If you reject them, then the minister becomes the decision maker. It is likely, however, in the judicial review of a minister, your own decision making would also be reviewed.
So it doesn't ever really go away. That's what you're saying. The legal risk still is there as part of a process where the minister's decisions would be judicially reviewed.
Yeah, the name on the case changes.
Okay, great. Thank you.
Councillor Pennant.
Just in terms of the Gordon Wilson flats or any other listed heritage building, my understanding is that there has to be, to get it on the list in the first place, you have to say why it's got heritage value. So if councillors, have a view, or the minister, that you could use it for a better use, or it's expensive to fix, are those issues that you can take into consideration, or can you only look at why it's got the social and cultural and economic value, historic values?
So if there are submissions saying that there is a better use, then yes, you can consider those. You're not restricted to necessarily the 4 wellbeings or only Section 6 matters of the RMA.
But whether it's got another use in some sense is irrelevant to any heritage object, whether it's got heritage value or not. It's sort of intrinsic in its existence and the evidence which supports it.
So I guess what you're asking me is, could council effectively decide against that evidence?
Yeah, or just that it's something's heritage value it stands on its own. It's irrelevant about the economics or whatever, and the evidence has got to be there that it doesn't have heritage value, rather than whether there's some other consideration which has got nothing to do with heritage.
Well, the power to delist the buildings that are in this process exists. It's up to council how it exercises that power.
Thank you.
Any further questions? Councillor Randall.
So just to complete the process thing, could you briefly outline what happens after we make our decisions tomorrow, and roughly the time frame? Thursday, sorry. After we make
That's all right.
Thursday. Sorry, there's so many decisions.
It's a big week.
It's a big week. So what happens after Thursday, briefly, and what is your sort of expected time frames as far as you know?
So after Thursday, myself and my team will then draft those successful resolutions and amendments into a letter that will go to the minister. That letter will outline what has been decided by the council, what are the reasons for that. that will then be sent to the Environment Ministry. The Environment Ministry will then set that into a briefing that will then go to the Minister, and the Minister will then make his decisions. We don't have a time frame for that occurring. There isn't a statutory time frame for it. For those parts of the plan that are not sent to the Minister, they will then go through a process of being made operative. If Adam McCutcheon is there, would he mind coming forward and he can give you the time frames on that?
Through the chair. Unfortunately, it's a little bit of a complex process, but to try and simplify it, we will prepare the public notice to announce your decisions on this tranche of decisions on the district plan for publication in April. What that will trigger is, for the non-intensification provisions, the opening of an appeals period of 30 working days. It will also trigger the, operationalising of those intensification provisions, the ISPP provisions, shortly after that public notice goes out. So there'll be two separate tracks of the plan starting to have effect, where some can be appealed and others will just become the new rules in effect.
And so just to confirm, assuming that most of the proposed district plan rules are not amended, but are agreed to, they actually start to become operative in April.
Through the chair, that's correct.
Okay. And lastly, can we get some assurance that the Minister Bishop also has to read 4,000 pages of IHP reports?
Happily, it is not my power to require a Minister of the Crown to do anything. We will make them available to him.
Fabulous. I think that's us for now. So what we're going to try to do is bring the water meeting to 3 o'clock. Yeah? Yep. Sorry, Tim. I saw a look of shock on your face. Great. But so just hang about and we'll just get confirmation.